Good evening, everyone. Welcome to the Winnebago County Board meeting. Tonight is Thursday, September 29th, 2022. Tonight's invocation and pledge allegiance is going to be given by board member Kevin McCarthy. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Mr. McCarthy. Mr. Thompson, are there any agenda announcements tonight?
No agenda announcements, Mr. Chairman. Just a reminder to board members that when you speak to please unmute your microphone. They're all muted at the beginning of the meeting, but when you go to speak, please tap the disc in front of you. And if you need help, we have some IT staff people here that can show you how to unmute it, but just remember to do that. Thank you.
Thank you, Mr. Thompson. Clerk Gumma, can you please call the roll?
Certainly. Thank you, Mr. Chairman. We will start with Mrs. Red. Mr. Salgado. Mr. Schultz. Mr. Sweeney. Mr. Tassoni. Mr. Webster. Mr. Westcott. Mr. Arena. Mr. Booker. Present. Mr. Butita. Here. Mrs. Crosby. Here. Ms. Fellers. Mr. Gurl. Present. Mrs. Gorel. Present. Mr. Hoffman. Present. Mr. Kelly. Mr. Lindmark. Present. Mr. McCarthy. Present. Mr. McDonald. Present. Mr. Neighbors. Thank you all. Mr. Chairman, 18 board members present, 2 board members absent.
Thank you. We do have a quorum this evening. Moving on our agenda under awards, presentations, public hearings, public participation, and proclamations. We only have public participation this evening. We have several speakers signed up. I'm going to read a statement from the Winnebago County Board. Comments shall be limited to 3 minutes. Speakers may not address zoning matters which are pending before the ZBA, Zoning Committee, or the County Board. Personnel matters or pending or threatened litigation may not be addressed in open session. An individual may speak a maximum of 3 times per calendar year on the same topic. This prohibition shall include the repetition of the same topic in a statement on what is purported to be a different topic. Personal attacks or inappropriate language of any sort will not be tolerated. Our first speaker this evening is Mr. George Foggerstrom. Come forward, please.
I'm George Foggerstrom. I'm a lifelong resident of this Winnebago County. I'm a Vietnam veteran of honorable service. During that time, if you were to call the 1st Cavalry Division and ask for a tunnel rat, you might get me. If you asked for a spray mission of Agent Orange, you might get me. If you asked for a flamethrower you might get me. In fact, you'd be getting the only one in the platoon that was qualified. If you ask for assistance setting up a tighter perimeter with equipment, explosives, anti-personnel, there's a good chance it'd be me. When a sniffer mission from G3 was ordered, I was one of 6 that did it out of a 20,000-man division. But somewhere along the line, when I got out, this thing is the DD-214. A lot of spots on it are wrong. You have an organization, the Winnebago County Veterans Assistance Commission has the authority to try and correct it. And I can't get anybody there to talk to me. In fact, I've been told that that capacity, which they had to correct those errors, they've chosen to do nothing, didn't file a claim, I did. When it came time was running out, I decided I'd file it myself. When denied, they didn't appeal, I did. At the appeal, they were a no-show. I went to Chicago, nobody was there, nothing. The VA in 53 years has done nothing for me, and I get no support from any of these people. Make no bones about it. If you sent their budget to public aid, it would be better spent. If you want to argue any points with me, I'm more than willing, but there is a deal. At that point in time, you want to argue it, I'll prove it. But then you're buying at my choice of bars, and you're buying for everybody in the bar. So, with that, I, George Foggerstrom, resident of Winnebago County, hereby revoke the power of attorney given to the Winnebago County Veterans Assistance Commission, September 29th, 2022. My DD-214 is so messed up. I was awarded this in Vietnam. By my DD-214, I can't wear it. But here's the award. If I have to dig it out, I'll dig it out, but we're going to a bar. Thank you.
Thank you. And thank you for your service. Our next speaker is Reverend Earl Dotson, Sr.
The Bible. Wisdom gives us a spirit of trust. God will take care of such a person, and that person should never be afraid of anything. As our organization awaits a positive response from the United States Department of Commerce to our request for $25 million, we are excited about receiving a few $100 million of that to reopen Church School and an adjacent facility for research and development. Church School will focus on advanced training in and an adjunct facility next door will deal with research and development. But we will focus on advanced manufacturing training. This research and development facility will house science, technology, engineering, and math professionals earning an average of $84,000 a year. And we are alerting the residents of that neighborhood about this exciting opportunity that was part of the deal, the Science and Chip Bill signed into law last month by President Biden of $280 billion. We are contacting the 10 historically black colleges and universities that have outstanding STEM programs. Alabama State, Jackson State, Prairie View, Spelman, Alabama State. We're telling them some of you students probably came from Rockford. Come on back home, because we're going to have a research and development facility that will emphasize that these young black forgotten Einsteins will have a chance to validate who and what they are. What person with what purports to be a functioning cerebrum wouldn't want to see such a development on the west side of Rockford, benefiting the Commonweal, validating our wisdom, moral stature, all rooted in trust in God? I close with these words from the Black National Anthem. Stony the road we trod, bitter the chastening rod, felt in the days when hope unborn had died. Yet, with a steady beat, have not our weary feet come to the place from which our fathers sighed. God of our weary years, God of our silent tears, thou who hast brought us this far on the way, thou who hast by thy might led us into the light, thou who hast taught us on the way, keep us forever in thy path, we pray, lest our weary feet stray from the place from where we met thee, lest our hearts drunk with the wine of the world, we forget thee. Shadowed beneath thy hand, may we forever stand, true to our God, true to our native land.
Thank you, Reverend. Our next speaker is Reverend Dr. Matthew Johnson.
Good evening. Later on your agenda tonight, you're voting on a resolution to tell the state legislature to repeal the Safety Act. And I'm here tonight to urge you to vote no on that motion that is before you this evening. The Safety Act, of course, is a very large bill, and in voting to say to the state legislature they should repeal it, you're also voting to say that they should repeal training money, support for first responders, the whole set of provisions. But some of you are objecting to a small portion of that bill, the Pretrial Fairness Act. What I want you to know tonight is, first of all, that the folks who are incarcerated in the county jail, awaiting trial, are innocent until proven guilty. Not police officers, not prosecutors decide whether someone is guilty. A judge and a jury does that. These folks are not guilty of a crime, they're accused of a crime. If I had enough money, I could bail out everyone held on cash bail right now, and they would be out tomorrow. The only reason some of those folks are in jail is because they can't pay their bail. But folks who can pay their bail, regardless of their crime, in most cases are allowed to go free and await trial, based not on the severity of their crime, but the size of their pocketbook. A bunch of clergy in Winnebago County have issued our own proclamation, which holds as much legal weight as whatever you might pass this evening. And that, I think, has been passed among you. It tells you that we oppose an effort to undercut the Pretrial Fairness Act. Our justice system should be based on the threat to folks, the truth, and not on whether or not you can pay. Are there changes to clarify the bill that need to be made and are likely to be made in the veto session? Sure there are. And you could contribute to that conversation by making specific suggestions for changes, and some of you have probably done that. That's great. But saying we should repeal the whole bill is, let's be fair, partisan politics, not policy making. So as a leader of a faith community in our town, and as one of many who have spoken about this and have worked for this for years, who have participated in many public hearings and debates for years on the bill before it was passed by the legislature, and are participating in efforts to make it better. Everything new needs work to make it better. I urge you to vote no on the resolution tonight, to instead attend all of the programs and trainings that are being offered by folks at the NAACP and folks at Rockford Urban Ministries to find out more about the bill and to figure out ways that it could be worked better here in our community. So I urge you to vote no tonight, and thank you for your time.
Thank you. Our next speaker is Mr. Dick Randall.
I'm Dick Randall, and I represent Eliminate Racism 815. As was just mentioned, there's a resolution later this evening that is going to be voted on that would hold up an entire bill because of one part of that bill. As I have read and listened to on the radio and seen some of the things that have been said about bail bond, it reminded me of a saying that I ran across, that a person who didn't know anything about something could still argue against it. And I would like to suggest that there's a great deal of misrepresentation about bail bond. I was on a Zoom call that was hosted by the Illinois Supreme Court's administrative team just recently. The state of Illinois, like at least 10 other states in the United States right now, is developing an assessment tool that every judge would use. They would have a trained person from their county who would use this to determine whether a person should get bail. And they would have a great deal of backup on this in terms of the fact that it is going to be very thoroughly researched before it starts being used. Anything that I have read about not having bail mandatory for everyone indicates that the great majority of people who are out without bail do not flee, they do come to their hearings. And a second thing is that crime has not gone up in areas and communities that have done this. So I do think it's a very important thing to really read the law, the Safety Act, because there are things in this resolution that are, if not just misunderstood, basically not based on the reality of the Safety Act. And so I am opposed to the Safety Act being suspended or halted for a period of time.
Mr. Rundle, your 3 minutes are up. Thank you. Our next speaker is Mr. Paul Bates. Come forward. Yes.
Prone to do that. Thank you for your time. My name is Paul Bates. I am the president of the Board of Trustees for the Natural Land Institute. And I'll give reason and requested action up front in case I take too long. The reason I'm here is because we are very, very interested in making sure that Belleville Prairie is saved. Belleville Prairie is on the airport property. I'll tell you more about the threat in a bit. What I'm asking you to do is to urge your two representatives on the Airport Authority Board to push Mike Dunn, the director of the airport, to request federal funding, which we think is available and have gotten some assurance from Senator Dick Durbin that it is. So back up a tad. Thank you, Ellen Rathbone, for the sign. The airport is going to do a major cargo capacity expansion. I think that's well understood around town, through the county. But their current plan is to bulldoze the Belleville Prairie, just eliminate it. Belleville Prairie is a very, very rare type. It's a dry gravel prairie. They only occur at the maximum advancement of glaciers during ice ages. When they retreat, they leave strips of gravel. Obviously, that soil is real different than the beautiful fertile soil we have elsewhere. Different soil, different plants, different animals, some endangered or threatened. There are only about 20 acres of dry gravel prairie remaining in the state of Illinois, the entire state. The airport has 5 high-quality acres. As a land conservation organization, we just can't fathom having that bulldozed because of a plan which currently chooses to put a road right through the middle of the highest quality area. We hired an engineering firm to do an assessment of 6 preliminary plans that the airport staff put together. Our consultant found that one of those plans would meet all of the criteria of the airport for the expansion and would entirely miss the highest quality portions of the prairie. The airport won't talk to us, hasn't for a year. We've tried. As friendly constituents, through lawyers, nothing goes. Our executive director has spoken in the last 3 or 4 months to representatives from Dick Durbin's office and Tammy Duckworth's office. Senator Duckworth indicated that she supports it, but because of committee assignments, she would like to have Senator Durbin lead the effort. Senator Durbin has said that if the airport simply makes a request to him, he will help them get an appropriation that he believes, especially with President Biden's recent proclamations about environmental protection, that he could get enough of an appropriation to pay 100% of any additional engineering costs and 100% of any increases in construction costs. So I'm really perplexed why they don't make that request. It's right there waiting to be plucked off the tree. Even better, on Tuesday, our executive director and I got to have a conversation face-to-face with
Mr.
Governor.
Bates, if you want to finish that thought, your 3 minutes are up.
Okay. We had a conversation with Governor Pritzker on Tuesday. He told us he's entirely in support. All 3 of them, though, said procedurally they can't move unless the airport makes the request to Senator Durbin. I'd like you to urge your 2 representatives in the airport board to ask or to instruct Director Dunn to make that request of the senator's office. Take the money which is being offered to us.
Thank you.
Thank you very much.
You're welcome. Our next speaker is Shelley Hutchinson.
Good evening, everyone. My name is Shelley, and I'm the Assistant Director of Nursing at River Bluff Nursing Home, where I've been employed in various roles for the past 29+ years. Tonight, I'm asking you to do the right thing. Vote to increase the tax levy for River Bluff. The county taxpayers overwhelmingly voted for the increase when the question was posed to them back in July. There seems to be some political manipulation going on in regards to this issue, but the residents of River Bluff deserve better. There hasn't been an increase in 33+ years. The citizens of this county voted to increase the levy, not in 2024, but now. To those board members who support River Bluff and are in agreement that the voters' opinions matter and think the increase should happen now, I want to say thank you. Thank you very much. For those of you who may be on the fence about the issue, I implore you to listen to your constituents. They have spoken with their vote and deserve to have their voices heard. Some voters are upset and feel ignored. You're elected to be the voice of the people you represent. The majority of the taxpayers who voted think the small increase in their property tax is well worth it to ensure that River Bluff not only remain in the county, but is able to thrive. River Bluff has a tremendous support in the community. Think about it. We're in a recession with inflation at a 40-year high, and yet people voted to increase their taxes for River Bluff. What was the point of the referendum if you weren't going to grant the wishes of the voters? We've been hearing how River Bluff is in dire straits and needs funding. Well, you would have the necessary funding with the increase in the tax levy. Many of us at River Bluff have been getting questions and comments from people in the community like, why did I bother to vote if the board is just going to do what it wants to do anyway? That tax money better go to River Bluff and not other departments in the county. Or I bet if the vote would have gone the other way against River Bluff, they'd be in talks with potential buyers right now. What should be concerning to you is the overwhelming number of people who believe that some of the board members are not being transparent or representing the wishes of their constituents. Voters are paying attention to what the board does. River Bluff needs funding in order to retain our staff and attract the most qualified new employees. We use a lot of agency staff right now, but if the wages were more competitive, we would be able to recruit our own nurses and CNAs as well as other employees. We need updates and repairs to our building as well in order to attract not only long-term residents, but younger clientele who maybe just had a hip or a knee replaced and only require a short stay for rehab. We have so much potential here, but we need the increase in the tax levy in order to be competitive and reach our potential. As I mentioned before, I've been employed at River Bluff for almost 30 years and have been through numerous attempts over the years to either shut down or sell River Bluff, and it never works. Why? Because the members of this community understand the valuable service that River Bluff provides its citizens and want that service to be available to them and their loved ones if one day they need them. Bottom line is this increase in the levy needs to happen now, not later. Inflation was high back in July when the voters agreed to increase the levy for River Bluff. That should tell you right there how important River Bluff is to this community. So please do the right thing. Thank you.
Thank you. Our next speaker is Mr. Daniel Ortega, Jr.
Good evening, ladies and gentlemen. My name is Daniel Ortega. I am the Director of Nursing at River Bluff Nursing Home. Let me remind the audience, River Bluff has been in service to our community for over 100 years. Over these years, the question of River Bluff's value to the community has been brought into question numerous times. The community has always emphatically given their support. The board, however, has always given mixed messages about the future of River Bluff. When I first started here, I remember the rumor circulating that we might not have a job, that the residents might lose their home, that River Bluff might close its doors indefinitely. And this has not happened only once, but 3 times since my employment here. These mixed messages have impacted our ability to keep River Bluff at its fullest potential. We have been directed to eliminate staffing agencies, but not have been given the resources to do so. We have been directed to increase our census, but how does the community put its faith in River Bluff when its future is always in question? We do, however, have a solid support in the community. I thank the board members who have given their support to River Bluff and believe this facility is a necessity to the community. We provide quality of life to those who cannot care for themselves. Many of our residents represent the diversity of the citizens of our community. We have provided care to veterans, artists, laborers, sports figures, and politicians. And now that the citizens of Winnebago County have voted to support us, we request the increase in the tax levy be implemented now, not in 2024. We have faced many challenges, recently the most devastating being COVID. The most recent challenge River Bluff has faced amongst many is its need for increased funding. The increase in the tax levy will provide the needed funding as well as replenishing our reserve. Our reserve has been utilized by other departments throughout the county in the past. It is time to replenish our reserve so River Bluff can confidently face future challenges. The community voted to take money out of their own pocketbook to fund River Bluff. Now it is time to honor their vote. Thank you to the community for supporting us. Now we ask the board to support River Bluff. Thank you.
Thank you. All right, that concludes our speakers for the evening. And we'll move on to our item number 6 on our agenda. Can I entertain a motion to approve the August 25th, 2022 minutes and lay over of the September 8th, 2022 minutes. Is there a motion by Mr. Neighbors, second by Mr. McCarthy? Is there any discussion on the minutes? Hearing none, are there any board members opposed to that motion to approve and lay over? Very good. Please cast a yes for all members present. Number 7 is the consent agenda. Can I entertain a motion to approve the raffle report and the auditor's report? Moved by Ms. Red, second by Mr. Earl. Is there any discussion? Very good. Are there any board members opposed to that motion? Very good. Please cast yes for all members present. Number 8 are appointments. Per county board rules, board chairman appointments require a 30-day layover unless there is a suspension of the rule. Our first appointment of the evening is Winnebago County Health Department. There's no compensation for Mr. Derek Coons. It's a new appointment. That will go from October 2022 to October of 2025. The second appointment is for the Seward Sanitary District. That also has no compensation. The first is Kelsey Heaslip. That is a new appointment from May 2021 to May 2024. And the second to that board is Dennis Hill. That is a reappointment from May 2022 to May 2025. Okay, we'll move on to reports of standing committees. The first is the Finance Committee with Mr. Jaime Salgado.
Thank you, Mr. Chairman. The Finance Committee has one item today and then one unfinished business, so I will take those two at this time. So the first one's a resolution awarding outside auditor service, and I so move.
Moved by Mr. Salgado, second by Ms. Crosby. Discussion?
Yes, just real quick, this is essentially the auditor, as everybody is aware, especially the finance. There was 3 RFQs that came in, and so Baker Tilly came out with the best scoring on that. Clifton Larson Ellen was the other one, and Sickich. Everybody should have got this packet with the timing and fees for $170,000 for 2022 and going forward. I think it's page 9 if you want to review that. But so this is giving obviously the awardee to Baker Tilly.
Very good. Is there any board member discussion on this resolution? Hearing none. Are there any board members opposed to this resolution? Very good. Please cast a yes for all members present. Mr. Salgado.
Thank you, Mr. Chairman. Our next item is the unfinished business, which is our annual appropriation ordinance. This was laid over on September 8th, 2022. So I'd like to make that motion and approve that.
Moved by Mr. Salgado, second by Mr. Earl. Mr. Salgado.
Yeah, if they're, obviously everybody got this packet here with a resolution of the different amendments, which is $1.8 million. If you look at page 2, so I'd like to move these items forward, if I may, as an amendment. Obviously, the first one, if you look on page 2, the total is 1.8, but I'll read them real quickly so everybody's aware of what those are. If there are any questions, we can have discussion about that, but I'd like to take those all as one, the 1.8 million. So the first one is Fund 0001, General Fund. That's obviously a negative of $2,205,045.50. That's proposed on that. The next one is Fund 0101 PST, negative $200,000. And then the next one is 0114, the ETSB 911. That's a negative $80,000. And then the next one is 0151 Commissary Fund, negative $200,000. Next fund is 0155 Memorial Hall for $9,600 negative. The next one's 0161 Highway Department, negative $131,306. The next one is 0164, the motor fuel tax, which is a positive $323,893. And then the next one is a 0401 River Bluff, and the positive of $779,600. And then the next one is Fund 0410 Animal Services, in the negative of $15,740. And the final one is Fund Item 0420 in the amount of negative $64,000, which equates to a negative $1.8 million is the amendments that goes with this ordinance appropriation at this time.
Okay, so Mr. Salgado moved to amend the annual appropriation ordinance. Is there a second? Mr. Tassoni seconds that motion. Is there any board member discussion on the amended appropriation ordinance? Ms. Red.
Mr. Chairman, if I may?
Yes, please.
Just real quickly, this is the current status that the Finance Committee voted to leave the tax levy flat. So I just want to make sure, for clarification purposes, these amendments are part of the adjustments after the ordinance was adopted. So I just want to be clear what this is so everybody understands.
Very good. Ms. Red?
Chairman, Mr. Salgado, can you explain that software subscription, please?
Which one?
It's for the jail. Software subscription.
The software subscription?
Yes. What is, what?
That's a 400,000. So I would defer to someone from Public Safety or Mr. Rickard if you have more information. It's on the jail management system.
Yes, Mr. Chairman, the software system used to track prisoners within the jail is end of life as of the end of this year. We also want to get a unified system that will make that system more efficient and be able to track our prisoners. What the sheriff has offered is he's going to take half of that cost out of his commissary fund to cover that expense for the prisoners, and PSST would cover the other remaining half to meet this budget obligation. And we have a representative of the sheriff's office if you want more detail on that software package.
I guess I have another question. Are the, for the medical part of it, are the employees involved in suggesting what should be used? Say the nurses or the medical people, are they involved in any of that?
I would have to defer to a representative of the sheriff's office to give some details at how they arrived at this software package.
I think Mr. Majors has his hand up.
Thank you. So this software isn't related to the medical piece. The medical piece is a different software that's already licensed. This software is strictly for the inmate management within the jail. And to answer your question as far as that's concerned, yes, the command staff within the jail, as well as some of the frontline workers, have been involved with all of the demos and other things that are going on with that software procurement.
Thank you. Do you know if the medical part will be coming up for review anytime soon?
I can't speak to the actual medical contract for nurses in that. The software itself was just implemented within the last, I think, 6 months or so. And does that answer your question?
Yeah, it does. Thank you.
Thank you. Ms. Gorel, you had your hand up.
Yes, thank you, Chairman. I would like to make an amendment for the Finance Committee to return River Bluff levy to its original request by the voters of Winnebago County, voted on June 28, 2022, to raise the levy. By raising the levy, as per voters' yes vote, they have voted for the sustainability of River Bluff. But this is what the Finance Committee keeps asking us for proof of, and we've given it to them. And yet they decided to hold it off until 2024. What is there to say that it would be implemented on 2024? Is there anything that says we can do that? Are we going to continue to kick it down the line, and maybe one day it'll be used up by some other parts or other offices? I would like to see that go back to what it should be, what the voters asked us to do. And voters are very upset, even though they know that this was an advisory. We didn't have to take their advice, but they're really upset that we didn't. That's why they voted to go ahead, and for the little amount that's going to cost them for a year, and like they say, with everything else right now in turmoil with finances, they're willing to do that. Then we should be willing actually to honor their request and go ahead and put that levy in right now. And if we can't, I know it sounds silly, but I want something in writing that they will do it in 2024. Because I don't want to see this go down and down to the next year. Next year, they're going to come back, oh, we'll put it down another year. This has been going on for too long. Do what the voter has asked. Do it the right way. Thank you.
So you have a motion to amend the budget to include, to raise the levy, the allowable amount for River Bluff.
Yes.
Is that your
now.
motion? Is there a second to that motion? Yes.
So are we, this is an amendment to the budget. So are we amending the amendment?
Right, there's already a motion on the floor.
Oh, that's correct. We were already amending, so we'll take care of the first amendment, and then we'll come back to your amendment.
Okay.
Is that okay? Thank you. All right, so we have an amendment that includes the $1.8 million adjustments. Is that correct, Mr. Salgado?
That's correct.
And we also had a second by Mr. Tassoni. Is there any other discussion on that amendment? Mr. Earl.
Thank you, Mr. Chairman. I'm just looking at the amendments here. Page 5 is a budget amendment for River Bluff in the amount of $1.3 million. And I guess my question is to Mr. Rickard, does that fully fund River Bluff to its full needs in 2023?
Mr. Rickard?
Can you repeat the question, please?
So does the budget amendment that we are voting on for River Bluff in the amount of $1.3 million fully fund River Bluff operations for 2023? Page 5. The transfer from the general fund to River Bluff.
That should bring, as long as there are no adjustments to the budget, that will meet the bare minimum to bring their fund equity balance to zero, yes.
Okay, excellent,
If
thank you.
That answers your question.
It does, thank you.
Very good. Is there any other board member discussion on the amendments? Ms.
May I answer his question?
Sure.
First of all, will this put any of the money into their reserves that have been taken from the River Bluff? Their reserves are down. If we have another pandemic, if we have, this is like an insurance company. We have to use the products. We have to use the medication first. And then we apply to Medicaid and Medicare to reimburse us. If we don't have a reserve that we can take that out of, what good is it? That levy needs to go in now. We don't need a zero balance. We need a good balance so we can go back to having a reserve there. Where would this county be if we didn't have a reserve? It's the same thing with River Bluff. They need to have a reserve, and you're not doing it. You're putting them at zero. Bad business. Thank you.
Thank you, Ms. Squirrel. Is there any other discussion on the amendments? All right, hearing none, are there any board members opposed to the motion to amend? All right. Please cast a yes for all members present. Now, should we take Ms. Gorel's? Okay, Ms. Gorel, you're motioned to amend the budget to raise the levy for the allowable amount for River Bluff, correct?
Yes.
Okay, is there a second? Ms. Red seconds that motion. Is there discussion on this motion? Any board member discussion? Mr. Arena.
Thank you, Mr. Chairman. So I just want it to be known to my constituents and the public in general that I fully support maintaining River Bluff, continuing its operation. I think it's an important asset to the community. When we, the Finance Committee, I think it was whichever committee it was that put this resolution for the tax increase on the ballot, it was done at a time when we expected our revenues to be less than what they actually turned out to be. So I'm not in favor of this, this amendment to raise the levy for River Bluff, only because we don't need the money. We have, and I understand Ms. Gurl's point that about reserves, but there is enough money in our aggregate funds to properly maintain River Bluff, at least over the next year. And there's been mention that we would raise it in 2024. We don't have to wait till 2024. If necessary, we can revisit this next year and raise it in 2023 if we don't receive revenue from these other sources like we did this year. So again, I just want it to be known that I'm supportive of River Bluff, but I'm not in support of raising taxes unnecessarily. Thank you.
Thank you. Any other discussion on Ms. Gorel's amendment? Very good. I'm going to take a roll call vote. Clerk Gamon.
Thank you, Mr. Chairman. We will start with Mr. Salgado.
Yes.
Mr. Schultz.
No.
Mr. Sweeney.
No.
Mr. Tassoni.
Yes.
Mr. Webster. Mr. Westcott. Mr. Arena.
No.
Mr. Booker. Mr. Butita.
No.
Mrs. Crosby. Ms. Fellers. Mr. Gurl.
No.
Mrs. Gorel.
Yes.
Mr. Hoffman.
Yes.
Mr. Lindmark.
No.
Mr. McCarthy. Mr. McDonald.
No.
Mr. Neighbors. Mrs. Red.
Yes.
Mr. Chairman, that is 9 yes, 10 no, and 1 board member absent.
Okay, so the motion fails. Okay, Mr. Salgado.
So that concludes our report.
Well, I think you want to
Real
vote
quick,
on-
one thing.
I believe we need to vote on.
The regular appropriation, that's
Yes,
correct.
the amended.
So I move to approve the appropriation as amendment with the budget amendments.
Moved by Mr. Salgado, second by Mr. Gurl. Is there any discussion? Hearing none, are there any board members opposed to this motion to approve the appropriation as amended? Do a roll call? Okay. Requesting a roll call, Clerk Gamon.
Thank you, Mr. Chairman. Start with Mr. Schultz.
Yes.
Mr. Sweeney.
Yes.
Mr. Tassoni.
Yes.
Mr. Webster. Mr. Westcott. Mr. Arena. Mr. Booker. Mr. Butita.
Yes.
Mrs. Crosby. Ms. Fellers.
Clarification, we're voting on passing the budget itself, correct?
Correct, the amended, with the amendment, yes.
Mr. Gurl. Mrs. Gorel.
No.
Mr. Hoffman.
Yes.
Mr. Lindmark. Mr. McCarthy. Mr. McDonald.
Yes.
Mr. Neighbors. Mrs. Red.
Yes.
Mr. Salgado.
Yes.
Mr. Chairman, that's 18 yes, 1 board member no, 1 board member absent.
Very good. Motion is approved.
Yeah, just one more thing. Mr. Rickard, I know you sent out an email to the Finance Committee about the bond rating. If you could just give a little bit brief synopsis, and so everybody's aware of it.
Okay, yes, we did get a bond, I'm sorry for the feedback here. Part of the process with bonding involves a bond rating from the bonding service. We did get our rating back from Moody's. They were very pleased with the increases in our finances. They were pleased with the number of initiatives we've done at the county to improve the financial picture. Unfortunately, they were concerned with the River Bluff situation and the county's lack of direction on funding. So that was a negative from the bonding authority. So they left our bond rating as the current position. So it's an AA3 rating. We have opportunity in the future to make efforts to improve that situation, and we will make presentations to the Finance Committee at a later time, giving some of those recommendations from Moody's.
And
Thank you.
that would conclude our report. Oh,
Mr.
yes,
Earl.
go ahead, Ms.
Thank you, Chairman. Just one question for Mr. Rickard. What is the bond rating for the state of Illinois?
The bond rating for the state of Illinois, unfortunately, I don't have that at the top of my head. I can find that out, though.
Okay. Would you assume that it's below where we're at?
I would not speculate where the state of Illinois is. I don't track their finances like I do the Winnebago County.
Understood. Thank you.
Thank you. Mr.
That
Salgado?
concludes our report. Thank
All
you.
right, thank you, Mr. Salgado. Our next report is from the Zoning Committee, Mr. Webster.
Thank you, Chairman. Your zoning committee tonight, we have 3 items on the agenda. These are all in for a layover. There's no need to suspend. So item number 1, for the record, SU 0522, it's a special use permit. And item number 2, Z 0722, that's a map amendment. And number 3 is Z 0822, that's also a map amendment. They're all 3 in for a reading. And Wednesday, October 12th, ZBA has a meeting, and then we follow up with zoning committee meeting Wednesday, October 26th. And that's all we have.
Thank you, Mr. Webster.
Thank you.
All right, move on to Economic Development Committee, Mr. Sweeney.
Thank you, Mr. Chairman. Your Economic Development Committee has 1 resolution. It is a resolution granting authority to the Winnebago County Board Chairman to execute the documents necessary to complete a loan for $50,000 from the revolving loan fund to get Munchies, Inc., doing business as Auburn Street liquidations, and I so move its adoption.
Moved by Mr. Sweeney, second by Mr. Westcott. Is there any discussion on this resolution? None? Are there any board members opposed to this resolution? Very good. Please cast a yes for all members present. All right. Mr.
Thank
Sweeney.
you. That is all we have. Thank you.
Thank you, Mr. Sweeney. Yes. Oh, Mr. Webster. I'm sorry.
Thank you. I forgot to mention that on number 1, SU 0522, that is a special use permit, so it comes with conditions. Thank you.
Thank you, Mr. Webster. All right. Mr. McDonald, Operations Administrative Committee.
Thank you, Mr. Chairman. Tonight we have 3 items. The first is a resolution awarding county construction project consultant, and I so move.
Moved by Mr. McDonald, second by Ms. Crosby. Discussion?
I have
None at the chair. Any board member discussion? Very good. Are there any board members opposed to this resolution? Hearing none, please cast a yes for all members present. Mr. McDonald.
Thank you, Mr. Chairman. The next item is an ordinance amending Section 2-65, limitation of debate, and 2-72, awards, proclamations, and presentation of the Winnebago County Code of Ordinances laid over from September 8, 2022 meeting, and I so move.
Very good. Moved by Mr. McDonald, second by Ms. Crosby, and those are under unfinished business, those two, last two.
Thank you.
Discussion?
No, sir.
None from the chair. Any board member discussion? Very good. Are there any board members opposed to these two resolutions? Or
One
ordinances?
ordinance, one at a time, please.
Oh, just one at a time?
Yes, sir.
So the first ordinance amending section 2-65. That's what's, any board member opposed to that ordinance? Hearing none, please cast yes for all members present. Mr. McDonald.
Thank you, Mr. Chairman. The final ordinance for this evening is ordinance amending section 2-81, presiding officer of the Winnebago County Code of Ordinances that had been laid over from September 8, 2022 meeting, and I so move.
Moved by Mr. McDonald, second by Mr. Webster. Is there any discussion from the chair? None from the chair. Any discussion from board members? Very good. Are there any board members opposed? Oh, Mr. Neighbors.
I don't remember this one. I was wondering if you could refresh me on this one.
Sure. What this is doing is, in the absence of the chairman, is the majority leader. And if both of them are gone the same night, we'll vote on who's going to lead the meeting.
Ms. Fellers?
In the event that the board is split 10-10 and there is no majority leader?
I understand your point, but if the majority's leader is missing, then we're at least at 19, so the odds are in our favor to have a split. I guess we'd run down Robert's rules from there.
What do we do it?
I'm sorry.
Flip a coin.
We'd have to be down 3.
Okay. Okay, we'd be down 3 then.
So it's just the majority of that evening, not the majority?
The members present, yes.
Yeah. Mr. Arena?
Thank you, Mr. Chairman. It was my understanding that it's the majority leader, then the minority leader.
Correct.
Okay, so.
So
she said, Ms. Fellers.
I apologize, you're correct.
Yeah, if both of them are missing, so there is a scenario where we could have a tie.
Yep.
Right, there's a scenario that after the next election, the board could be 10-10. It could be, or it would not be, I'm sorry.
Yeah.
I mean, we have an election coming up, and the election could be that we become a board that is 10-10. So in that case, there is no majority nor a minority leader. So that's my question.
Thank you, Chairman. So in that case, then the board at the time can amend the rules, so we can amend them back.
Probably 2,000.
Get that? Okay, good. Mr. Arena, did you want to follow up?
Well, I was just gonna say, if the, I mean, this is not a critical point, and I'm sure that, you know, if there was a situation where the board couldn't agree, faced with the prospect of having to sit here for an extended length of time, they can somehow make a compromise and figure it out. So it's a legitimate point, but I don't know that we need to delve into it. Thank you.
Thank you, Mr. Arena. Any other discussion on this ordinance? Hearing none. Any board members opposed to this ordinance? Very good. Please cast a yes for all members present.
That
Mr.
concludes the
McDonald.
report. Thank you.
Thank you, Mr. McDonald. Okay, we'll move on to Public Works Committee. Mr. Tassoni.
Thank you, Mr. Chairman. Your Public Works Committee brings forth 5 items for passage this evening. The first item would be a resolution authorizing the execution of an annual professional agreements with the various firms for land surveying, structural engineering, geotechnical materials, testing, and other related services, and I would so move.
Moved by Mr. Tassoni, second by Mr. Webster. Any discussion, Mr. Tassoni, and from the chair?
These are just annual housekeeping items. These monies will be doled out from the Highway Department as necessary for various engineering services.
Very good. Any board member discussion? Hearing none, are there any board members opposed to this resolution? Very good. Please cast a yes for all members present. Mr. Tassoni.
Thank you, Chairman. And if I didn't speak, the former resolution was 22-032 for the record. Second item is 22-033. It's a resolution authorizing an engineering services agreement with Willett Hoffman Associates, Inc. to provide design and permitting services to extend the county's water system on Baxter Road to the west side of I-39. I would so move.
Moved by Mr. Tassoni, second by Mr. Hoffman. Any discussion from the chair? None? Any board member discussion on this resolution? Very good. Please cast a yes, or, yeah, did I already ask that? Any board members opposed to that resolution? Very good. Please cast a yes for all members present. Mr. Tassoni.
Thank you, Mr. Chairman. Our third item is Resolution 22-034. It's a resolution authorizing the approval of a change in plans to reconcile bid quantities with as-built quantities for the 2022 patching program. It's a deduction in costs of $40,000 and some change, and I would so move.
Moved by Mr. Tassoni, second by Mr. McCarthy. Any discussion? Here. That was cool. Are there any board members opposed to this resolution? Very good. Please cast a yes for all members present. Mr. Tassoni.
Thank you, Chairman. Our next item is Resolution 22-035. It's award of a bid for crack sealing at various county locations, a cost of $140,000, $140,180, and I would so move.
Moved by Mr. Tassoni, second by Ms. Crosby. Any discussion? Hearing none, are there any board members opposed to this award of bid? Very good. Please cast a yes for all members present. Mr. Tassoni.
Thank you, Chairman. Our final resolution is award of bid. It's 22-036. It's an award of a bid for the rehabilitation of well number 1 for the Winnebago County Water District well house. It's a cost of $155,360. I would so move and speak to it as well.
Moved by Mr. Tassoni, second by Mr. McCarthy. Mr. Tassoni.
Thank you. And just for the board's notice here, it came in at a cost of approximately $100,000 less as our projection, so that's a good thing.
Very good. Any board member discussion? Yes, Mr. Schultz.
Thank you, Mr. Chairman. We had two items related to the water system tonight. I know that we also obtain revenue from the folks that are benefiting from that water system. Do we have a fund balance that's able to cover these expenses out of that revenue?
There is, and I believe this rehabilitation is in that. I would ask Mr. Molina or Mr. Rickard to speak to that if you'd like some detailed information.
Mr. Molina?
Thank you, Mr. Chairman. Yeah, both of these items are actually going to be covered by the 2012 bond. There's a balance of about $280,000 that we need to spend.
Okay, thank you.
Thank you. Any other discussion? Okay, are there any board members opposed to this award of bid? Very good. Please cast a yes for all members present. Mr. Tassoni.
Thank you, Chairman. That concludes our report.
Thank you, Mr. Tassoni. Okay, we'll move on to Public Safety and Judiciary Committee. Mr. Earl.
Thank you, Mr. Chairman. Public Safety and Judiciary Committee has one item for you this evening, and it is a resolution opposing the Safety Act and supporting its repeal in the Illinois State Legislature, and I so move.
Moved by Mr. Earl, second by Mr. Sweeney. Discussion.
Yes, thank you, Chairman. First, I would like to add co-sponsors. I apologize, but they were not added onto this resolution at its onset, so there was a request from board members to be added on. So if we could do that by a show of hands or roll call vote, that would be great.
It's up to the clerk how she wants to manage that. You want to do a roll call?
Okay. Okay, and then do you want to repeat?
So the question is, do you want to be a co-sponsor to this resolution? If the answer is yes, say yes. If it's no, say no.
Thank you, Chairman. We will start with Mr. Sweeney.
He is the sponsor, I'm sorry.
So that would be a yes.
Yes.
Mr. Tassoni.
Yes.
Mr. Webster.
Yes.
Mr. Westcott.
Yes.
Mr. Arena.
Yes.
Mr. Booker.
Yes.
Mr. Butita.
Yes.
Mrs. Crosby.
Yes.
Ms. Fellers.
No.
Mr. Gurl.
Yes.
Mrs. Gorel.
No.
Mr. Hoffman.
No.
Mr. Lindmark.
Yes.
Mr. McCarthy. Mr. McDonald?
Yes.
Mr. Neighbors?
No.
Mrs. Red?
No.
Mr. Salgado?
No.
Mr. Schultz?
Yes.
Okay. All those who said yes will be added as co-sponsors.
Thank you, Mr. Chairman. The resolution is before us. I have no discussion.
Very good. Board member discussion, Mr. Sweeney.
Thank you, Mr. Chairman. So the resolution kind of said, we've covered a lot of the material already, but there was an amendment after being at public safety the other night. Some discussion occurred, and we figured we'd tidy it up with offering an amendment. There's an aspect of the Safety Act, of course, that creates a rather large, and yet another unfunded state mandate that lands, on us to figure out how to fund all the additional, the manpower and the court calls and whatnot that the bill would entail. So I'm going to read in a whereas that would be added in to the resolution, and I'll hand a copy up after this, if it passes after.
So is this an amendment?
But it,
Clarification?
You can't hear.
it's green. So I'm going to offer up an amendment that says, whereas, and I so move, whereas the Safety Act creates a large unfunded state mandate by requiring additional hours of operation and additional staff-related costs pertaining to court and other public safety operations of Winnebago County. That's the amendment to add that whereas into the resolution.
Motion by Mr. Sweeney to amend the resolution with including another whereas. Is there a second? Mr. Arena seconds the motion. Is there any discussion on the amendment to the resolution? Are there any board members opposed to that amendment to resolution? Ms. Red is opposed? Please cast a yes for all other board members, please. Mr. Earl?
Thank you, Mr. Chairman. I would.
Excuse me, I'm not done.
Ms. Red?
Thank you. I was wondering if Mr. Earl could explain to us, and I think some of us are voting and really don't know what we're voting for. There's more than one part to that Safety Act. Explain to me what that Pretrial Fairness Act is, please.
We could have our state's attorney explain a little bit to us. I was not the author of this, but it is plain and simple that the county, in its opinion, feels that the Safety Act should be repealed, and there is a whereas in there. As an alternative to repeal of the act, the county board calls upon our General Assembly to delay the implementation of the act so that it can be extensively reviewed and debated and the appropriate changes be made. Further, the act's effective date should be delayed because the current confusion surrounding the interpretation of the act will likely create operational havoc in our courts. And that is the sum basics of why we think that our legislators should repeal this and amend it at the least. We could debate for hours and hours and go back and forth on opinion, and that is the problem with the Safety Act, that it creates so many unknowns, especially in the legal section in our criminal justice system, that the public is unaware of what the Safety Act actually does.
One moment.
Follow up, Ms. Red?
Yes, thank you. I think that we need to have a forum or a town hall meeting or something before we vote on this, because a lot of people don't know, and we're just picking out one part of it, and there's 4 parts to that. So I wouldn't, if you don't know what you're voting for, don't vote. You need to hear all of it.
Thank you, Ms. Red. I'm going to start over here with Mr. Salgado.
Thank you, Mr. Chairman. I do also in agreement with Ms. Red here. I don't agree, with the whole bill as a repeal. There's good parts of it. There's training, there's funding for, that portion of it. I hear about unfunded mandates about, the body cams by 2025. There's enough time for that. We're already, the Winnebago County has already the video cameras for officers. So there's parts in there that are very good, but the simple fact that to repeal the whole bill, from my perspective, I think I'm not comfortable with that. And, you know, from my perspective, therefore, if we could maybe, you know, if it's a cash bail bond or whatever portion of it, that we want to have that be repealed or whatever of the bill, whatever the case may be, maybe it garnishes more attention down Springfield for them to, I hear there's a trailer bill out there that's being proposed. So, I mean, what's the rush from my perspective? Let's take it back to committee or whatever from that perspective. And because I'm not comfortable with saying repeal the whole bill, because Mr. Hanley, I appreciate the information you gave me about, you know, the cash bail and non-detainable offenses and the claims and the facts. So I hear a lot of things out there with newspapers, similar situation. I don't know all the details from that perspective. So, you know, if we're focusing on the cash bail piece of it, because it's gonna create crime or whatever, we can certainly, you know, go that direction. But, you know, for me, for repeal the bill entirely. And this, some other thing that, you know, I want to bring up, this bill was passed like 2 years ago or whatever the case may be. So what's the delay on that aspect of it from that perspective? I hear there wasn't a lot of communication with the sheriff's department and state's attorneys across the Springfield or whatever the case may be. I don't know, you know, what really happened, what transpired on that. You know, it'd be good to have our state legislators come in as well and educate us on this bill and why this was proposed. So that's my recommendation. I mean, that's my comments. County board can vote the way they want to vote on it, but that's just my suggestion for that.
Thank you. We'll go down the line. Mr. Sweeney already spoke. Ms. Fellers. Oh, did you want to speak?
No, I didn't have my hand up.
Ms. Fellers.
I agree with Ms. Red and Mr. Salgado that, that asking that the entire bill be pulled back isn't something that I would support. There are things in the bill such as giving access to training, addressing things such as use of force. There's even a portion of the bill that prohibits shackling pregnant women who are in active labor. These are laws and rules that we need. And I think that if we have a problem with a very specific portion of it, we should be tailoring our communication to that specific portion of it. And we should all be, like Ms. Red said, we should know what we're voting for. Thank you.
Thank you. Ms. Corral.
Thank you. You've only had 2 years to do this. Why are we waiting till the last 2 months of this bill being enacted? There's been all kinds of seminars. There's been all kinds of, I know the League of Women Voters even had 2 or 3 of them trying to get the public to come out and listen to all this. So now we're down to the wire and we want to repeal it. 2 years you've had to do that. So where you been for 2 years? Thank you.
Thank you. Mr. Neighbors, did you have your hands up? No? Mr. Booker.
Thank you, Chairman. Right now, there's no fear of the police, judges, or juries right now. There's no fear. I have a question for State's Attorney, Mr. Hanley. At any time, well, let me back up. State Representative West was a co-signer from Rockford, was a co-signer on this bill. Did he, at any time, Mr. Hanley, organize a town hall, a roundtable discussion with you, your office, with the Sheriff's Department, the Chief of Police, prior to this?
I don't believe so, but if I recall, I was in the office a pretty short time. Thank you. My recollection is I was only in office a very short time before this bill was passed. However, I don't recall talking to anyone prior to the passage of the bill.
Chief Barcelona, did you recall any requests from Representative West's office to discuss the intents and purposes of this bill?
There was none.
I didn't think so. The Public Safety Committee of this county board, we reached out to Representative West's office to arrange that meeting. A couple of times. We tried. We got no response. Although he tells a reporter that he's available at any time. We received nothing. That's what really burns my backside the most, is that we tried to talk to him. He's co-sponsor of the bill. We got no response from him. In committee the other night, a board member asked the question, what do the experts think on this? And I responded, well, there's 102 counties in Winnebago, or in the state of Illinois. 100 state's attorneys are opposed to this bill. 3 state's attorneys have filed suit on this bill. 2 of those 3 are Democrats. This isn't a Republican or Democrat issue here. I'm just saying. The bill has several components, and the hot button has to do with this no cash bail. I get that, but there's other things that really hit my hot button too. And me being a retired police officer of 30 years, one thing that strikes me the hardest is that a law enforcement officer can have a complaint filed on him anonymously, unsubstantiated. I don't know how many of you would like to go to work and have just anybody anonymously an unsubstantiated complaint on the type of work you're doing. You know, and then I heard earlier tonight that the innocent are in jail. You're innocent until proven guilty. What most people don't realize is that when you take a suspect to jail, a probable cause statement must accompany the booking process, which means there must be sufficient probable cause, whether it's witnessed by a citizen, by the officer, or by a warrant issued by the courts, for that person to go into jail. So there's got to be sufficient evidence that that this person committed a crime. So, you know, the trial comes later, but the probable cause statement comes in there. And for those that are concerned about trespassers on your property, get this part. A person can sit on your front steps and call you all kinds of names, and you can call the police to have them removed. Police won't be able to remove them. They'll issue a notice to appear. And then they'll look at you and say, good luck, we're out of here. So I'm pretty confident that this board will pass this resolution to oppose this ridiculous bill. But we need to pray that that this criminal hugging bill will never go into effect. So I just wanted everyone to be aware of it. And I'm passionate about it because for 30 years of my life, I was out there. I was getting punched and kicked and spit on. And I was shot at once on Christmas Day. So I'm very, very passionate about this. And I agree that there are portions of this bill that are right. But we don't just push the bill out and have it passed now and then work on it later. No, we need to have it fixed now before it gets to the bad point. So that's where I'm at. Thank you.
Thank you. Mr. Arena? I'll come back.
Thank you, Mr. Chairman. I appreciate State Attorney Hanley providing us with some information here, and I wanted to ask, and you know, I understand that time's a factor, but if he could briefly just go through and kind of explain a little bit about the points in here that are most important for us to understand before we take this vote.
Sure. So well, first let me start with this. I would implore all of you to read both the memorandum and the attachments. I think they're extremely helpful, and they are written in a very factual way. I think we'll start here. The memo really deals with detainable offenses. There could have been multiple memos made on other parts of the Pretrial Fairness Act. You'll see in the footnote I talk about some of those other issues I could have addressed. But it's important to separate arrest from lodging and pretrial detention. So the Pretrial Fairness Act really doesn't affect arrest. That's when someone's put into handcuffs or not. Lodging is when they're taken to jail. And then there's pretrial detention. That's when you go before the judge, and the judge currently determines what your bail or bond is. Mm-hmm. And then in order to get out of jail before your trial or plea, you have to post that bail or bond. And so what this has to do with is pretrial detention, this memorandum. And that's been a lot of what's been talked about. And so what the memo kind of talks about are the steps that must occur for someone to be detained and the standards. And so the first step is, does a particular offense fall within the detention net? So that's kind of the first step that we as state's attorneys, before we file our petition to detain and the court must determine, is whether an offense is within that detention net. If it is within that detention net, then the second step is a judge must determine what standard applies. And there's two standards. There's a dangerousness standard and a willful flight standard. Those are not, and the standards as outlined in the memo are not currently what the standards are here in Winnebago County or anywhere in the state. They are more restrictive than what they are currently. In addition, there's some inconsistency, but nevertheless, the dangerousness standard, there really are three different dangerousness standards. One is the defendant poses a specific real and present threat to any person or the community. That's for non-probationable forcible felonies. And that's when, that's the community dangerousness. That's the only time you can argue that someone's a danger to the community. The other two standards are defendant poses a real and present threat to the physical safety of a person or persons. And the last standard is that the defendant poses a real and present threat to the physical safety of any specifically identifiable person or persons. Those are limited to the offenses identified in section 110-6.1A1 through 6. And I've listed those categories, generally the categories of offense. The next standard is willful flight. And I should have included the definition of willful flight. If you look at Exhibit A, willful flight means planning or attempting to intentionally evade prosecution by concealing oneself. Simple past non-appearance in court alone is not evidence of future intent to evade prosecution. That's available for all Class 3 felonies or greater. So by implication, a Class 4 felony or below, with the exception of domestic violence cases, because those can be Class A's, are non-detainable offenses. Someone can be arrested, someone can be lodged, they will go before the judge, and the judge's only option is to set pretrial conditions on that person. They cannot be detained prior to trial. If they were on pretrial anyone who's put on a pretrial release and they violate those conditions, they could potentially be detained for violation of those conditions after their initial appearance while they're on pretrial release. Then the third step is after you've figured out whether it's in the detention net and what the applicable standard is, and by the way, certain offenses would have both standards. You could have both willful flight and dangerousness and argue both of those, and a judge could find that someone fell under both of those standards. And then the third step is the application of the facts to the applicable standards. And that's just the facts and circumstances of the case, the history of the defendant. One thing that was mentioned earlier is Winnebago County has been using pretrial services reports for a long time. And those are evidence-based risk assessments. And what the AOIC is doing is having that be throughout the state. But Winnebago County has one of the best pretrial services divisions in all of Illinois, as a quick aside. I think one of the sections that you'll appreciate is the correcting certain claims that you've heard. And I do want to address that. That meme that you've seen on Facebook of the non-detainable offenses, aggravated battery, aggravated DUI, et cetera, that's on page 3 of 4 of the memo. That is not true. Those offenses are detainable. However, they are not detainable under the dangerousness standard because they are not listed in section 110-6.1A1 through 6. That is black and white. There is no debate on that. Rather, they are only detainable under the willful flight standard as they are Class 3 offenses or greater. The other claim, there is no such thing as a non-detainable offense under the Pretrial Fairness Act. That claim is not true. As I mentioned before, any Class 4 or below, or maybe more directly, anything not included in section 110-6.1 is a non-detainable offense. Starting January 1, the next claim, a judge must hold a hearing for anyone arrested for a serious felony, and there is a requirement that the judge perform this hearing to assess someone's safety. That is incorrect. Only the state's attorney, by a verified petition, can initiate that process. Lastly, and this is important, the Pretrial Fairness Act is not retroactive. That is one of the biggest open questions we still have. we have the impression from our judges here in Winnebago County that they will be applying it retroactive. What that means is these pretrial detention hearings will be happening between now and December 31, and they will issue stayed orders. Those orders will require that defendants are released on January 1. If it was applied prospectively, my understanding is some counties are applying it prospectively. Anyone with cash bail prior to January 1 would continue to have cash bail. So in other words, if they had cash bail set on December 1st at $100,000, they would have to post the 10% on January 31 in 2023. It would just be prospective in the sense that anyone arrested after January 21, it would apply. But the law as drafted does not provide really any guidance, or I shouldn't say that, definitive guidance on whether it's retroactive or prospective. That's generally a summary of the memo. I think the flow charts are particularly helpful as they're graphic representations. They were actually prepared by the commission, the Supreme Court Commission on Pretrial. That's a working group, and they put those out. That's as nonpartisan as it gets, and that is reflective of what's in the memo. I included a press release of Dan Wright, who is a well-respected state's attorney, who put out a press release which I think is very clear and factual, and I think he does a good job of explaining some of the difficulties with the Willful Flight standard. And then I attached 2 articles from the Illinois State Bar Association, and if you look at the authors of those articles, they are not state's attorneys, public defenders, or advocacy groups. They are simply attorneys who read the law. And so hopefully that's enough of a summary. But as I said, there are other subjects that you may have questions about. For example, who can be lodged and who can't be lodged. That in and of itself is probably an equally detailed memorandum. I'm happy to answer questions about that. What are the time frames for these hearings once someone is detained? Those are all separate subjects that, again, I'm happy to answer questions about tonight, but would be probably more detailed memorandums because each of those issues are their own. There are significant changes for each of those issues.
Mr. Arena, follow up.
Thank you. And there's been some conversation about different parts of the bills do different things. One of the things that's of concern to me is this change in the standard of what trespassing is. So the problem, as I understand it, is the level of crime that trespassing is changes with this bill. Do you know if that change was part of the Pretrial Fairness Act portion of the bill, or is it done outside of that?
I don't know. Well, there's kind of maybe 2 answers to that. If the elements of trespassing were changed, it is not in the Pretrial Fairness Act because I've read every word of the Pretrial Fairness Act. It would have to be in the other parts of the Safety Act. What the Pretrial Fairness Act did with respect to, let's say, criminal trespass is it made it so that an individual who is arrested for criminal trespass to land, that is a Class B felony, that individual cannot be lodged in the Winnebago County Jail unless 3 exceptions are present. The first exception is if that person cannot be identified. The second exception is if they are, and I wish I had it so I could say it exactly, but essentially if they were a danger to a specific person, an immediate danger to a specific person, and the last exception is if there was a mental health issue.
But the information that I was given is that trespassing would no longer be an arrestable offense. It's just can be a ticket can be given.
So yeah, so that's why the separation between arrest and lodging is so crucial. There is some different interpretations of that. So there's lots of reasons to arrest a person. In other words, put them in handcuffs or put them in the back of your car. Sometimes that's oftentimes for officer safety to de-escalate a situation. Sometimes you're even driving them away from the situation. My interpretation, and I'm okay saying this publicly, is that officers would still be able to do that under this law. What they would not be able to do is actually take them to the Winnebago County Jail and lodge them. They would have to give them a citation, which is essentially a notice to appear to go to court in 14 days. So if that person doesn't show up at 14 days, a warrant cannot be issued. A rule to show cause has to be issued, then that has to be served. Then if they don't show up at the rule to show cause hearing, a warrant can be issued, assuming they have been served.
Thank you for that explanation.
The others haven't spoken first. So, Mr. Webster.
Yeah, thank you. I want to be perfectly clear on that, what Paul had brought up and what Mr. Booker had brought up. So I want to be real clear on this. If someone's trespassing and I call the police and I say this guy is sitting in my front yard and I don't want him there, he's trespassing, or he's sitting on my step, my stoop, I don't want him there. He is trespassing. Now, so if the law enforcement comes and they give him a citation, they write him a ticket up there, said, here you go, that's it? So then they can't actually make this person physically get off of your property?
So some state's attorneys and some judges and some police officers have read the law that way. I've taken maybe a different view, and I believe that the law enforcement officers can remove that person from the land, from that trespassing as a immediate safety issue. However, they can't take them very far, and they can't take them to the Winnebago County Jail. One of the things that we've been doing is talking about real cases and looking at them each day, and we had a case for Monday, and I just used it as an example, where someone had gone into a store and was in the bathroom for, I think, almost 45 minutes. The fire department was called to open the door, and that person eventually came out, and he was charged with trespass. What happens if he were to come back 10 minutes later? What the officer has to determine is, what are their actions at that point? Is he a danger to that immediate threat to that store or the person in that store? Is there a mental health issue? And can they be properly identified? Absent those exceptions, that individual will be given a citation. They will not be taken to the Winnebago County Jail.
So they're given a citation, and they're saying, okay, mister, listen, this guy doesn't want you on his porch. Will you just please leave? That's as far as it can go, because what you're telling me then is that's about all the cop can do is say, please leave. So if the guy says, okay, walks across the street, the cop says, thank you, cop drives away, the guy's got the citation in his hand, okay? The cop drives down the street, the guy walks right back over, sits on the porch again.
So
There's nothing you can do.
I'm not sure what your question is, so I'm sorry, I'm not sure what your question is.
All right, I'll give you a classic example. Years ago, when I was a kid, there was a guy on our front steps of our home. And so the guy was totally intoxicated. So my father called the cops. He didn't want to deal with this guy. He said, there's a guy in our entryway of our home. He walked in, sitting in the entryway of our home. So the cops in that situation took him away. They didn't write him a citation and say, please, mister, can you go home and sober up? No, they didn't do that. They took him away.
So in that situation, the officer would have to determine whether that individual was an obvious threat to you and your family or the community. If they believe that was the case, then they could take that individual to the Winnebago County Jail. As I mentioned, while it's an open question and certainly open to interpretation, some would argue that that person couldn't be put in handcuffs, for example, and walked away from the porch. Others, including myself, would make the argument that they could be removed from that porch, but they couldn't be taken to jail again if those exceptions weren't present. So that separation between arrest, lodging, and pretrial detention is very important.
Does anyone haven't spoken yet? Mr. Tassoni, I'll come back.
Thank you, Mr. Chairman. Just to add my 2 cents on this take here, and I guess it's a broad range of discussion here, but I would say just something I read in the news this morning, and forgive me if this isn't truly accurate, but it's out of the news media here, but that, police the other day, yesterday, day before, they found a loaded handgun with a laser sight, another loaded handgun, a magazine with 29 rounds, 33 grams of cannabis, almost 1,200 grams of cocaine, almost 200 grams of heroin, 87 grams of mixed cocaine and heroin, $1,000 in cash. The individual was lodged in jail and released on a $5,000 bond. That in itself is as ridiculous as letting someone out with no bond, in my opinion. So whether or not this board chooses to vote in favor of an advisory to our legislation as far as what we disagree with, I don't think it's going to make any difference or what the end result will be. One of the thoughts I have, I've seen some statistics. If any given day we have 800 individuals lodged in the Winnebago County Jail, and if you want to believe half of them are going to be let free on January 1st, 2023, will we have the need for the amount of corrections officers that we do with half of the amount of inmates? And I'd like someone to speak to that. Thank you.
Were you looking for an answer, Mr. Tassoni?
Absolutely.
Okay, is there, the police, sheriff's department could answer that question? Mr. Barcelona.
Everything's hypothetical, but I will say that.
Yeah.
Yeah, come on up here, sorry.
Sorry. Everything's hypothetical, but I don't think any of us really know what this act's gonna do until we start getting into it. But eventually, the people that get released, and this is opinion, this is facts, we just don't know, but eventually the jail population is gonna go up because they're gonna violate their pretrial bonds, or pretrial arrangements anyway. And we're gonna catch up to them because they're gonna commit more crimes. And when they commit more crimes, the judge is gonna have to keep them in jail because they violated their orders in the first place. So eventually the jail population will go down, but how long is it gonna take to get back up? It's gonna be determined on how quick we catch up to the people that are violating the law in the pretrial conditions. So maybe initially, but I think eventually our population is gonna be probably where we are now, if not higher. But we really don't know until we start getting into it. So there's a lot of unknowns, and I think that's what everybody is debating. There's a lot of unknowns with this new law, and we're just gonna see. But if you look at New York, if you look at California, that's probably, in New Jersey, you should probably take a look at that and see what's going on there. Probably what we're in for.
Yes.
Thank you, Chairman. Just to follow up to that, I respect those comments there. And like I say, myself, I have deep concerns about it. I don't know where the end of it's going to unfold, but I have concerns, and hopefully it's not as all described. Thank you.
Thank you, Mr. Tassoni. Are there any board members who have not spoken yet who would like to? Mr. Please.
Thank you, Mr. Chairman. As we've all heard here, there's a lot of confusion as to what police officers shouldn't do, what are detainable, what isn't. Even the people that wrote the bill have said themselves, we can relook at it. We're not sure what's in all these enormous amount of pages that this thing has. Now, you're also putting first responders, judges, attorneys, for theirs already being scrutinized. Now you're putting more on them to decide if this is a charge, isn't a charge, can they be arrested, can they not? That alone would say that we need to send this back for repeal. I know that there are some different cases in this bill. It's not just the pretrial fairness. And I, for one, am dead set against this pretrial and the whole bill, the whole Safety Act. We're arguing about crime, alleged criminals. The state is going to put an enormous amount of burden on the budget of Winnebago County and the people themselves with this. They're not helping us out. And the big thing, Mr. Booker said, 100 of 102 state's attorneys are against this in the state of Illinois. We've seen it in the past when communities become lenient on crime and what has happened to those. The statistics prove that it does not work. Thank you.
Thank you, Mr. Lindmark. Mr. McDonald, you had your hand up?
I did, Mr. Chairman, thank you.
Thank you.
I agree with a lot of people here. There are good parts of this. There really are. But there's also some bad parts, and there really are. I don't believe Springfield for 1 minute is going to listen to us when we say, hey, please repeal this. I think the most important thing that we did in this resolution is ask them to postpone the implementation. I think that's the important part of this resolution is let's go back and make sure all the state's attorneys understand the impact, make sure all the sheriff's departments understand the impact. Let's have a good knowledge on what it really is going to do moving forward. Thank you.
Thank you, Mr. McDonald. Are there any board members who have not spoken yet on this matter? Mr. Salgado, did you have a response that you wanted to?
Real quick, has the Ms. Vaughn or Mr. Hanley, has the Supreme Court come out with any guidance on this and what the interpretation? Because there has to be some sort of interpretation. I would assume, I'm not in the legal realm of things, but once a case comes before, the precedence shows up and then it's followed that way. But I don't know in this situation, has there been any interpretation on, what circumstances a judge or the state's attorney, because I feel like it's going to put more burden on the state's attorney's office to file these motions, these petitions, to make sure that these guys don't get out, without being lodged or whatever the case may be. It just brings more burden on your department to file these petitions. It creates more work on that end from that perspective, but just wanted to see if the Supreme Court of Illinois has come out with an interpretation. I know the bar probably has come out, in support or against it, but I just want to know what the interpretation, because I get the sense that everybody has a different interpretation of the trespassing, this crime, that crime. Can police officers do this? Can police officers not do that? And so, just from my perspective, has any guidance come out? I'd like to know that.
State's Attorney Hanley.
So, the Illinois Supreme Court Implementation Task Force was formed, but they give lots of caveats. They are a working group, and they're there for resources. They are not an official resource from the Supreme Court.
So the reality is, what'll happen post-January 1 is people will start filing motions and appeals, and it'll work its way up to the Supreme Court after months, potentially years, to be hammered out. There will be, the Supreme Court and other courts do not, absent extreme circumstances, and this is not one of them, give advisory opinions. The litigation that was filed by state's attorneys, and there's more than 3 now, I think there's closer to 20, and probably there'll be more, are almost identical in that they're arguing that the law is unconstitutional. There's a chance that that may be heard by the Supreme Court prior to January 1. But in terms of the interpretation and how it would apply to specific defendants or individuals, that won't be coming. Although, in meeting with our working group internally, we have a pretty good idea of how the judges view this law. As an example, we have a pretty good idea that they're viewing this as being retroactive as opposed to prospective. But ultimately, that will have to be decided by an appellate or the Supreme Court.
Right. Okay.
Thank you, Mr.
Thank you.
Mr. McCarthy, did you speak already?
No, I have not.
Okay, please go
Chairman.
ahead.
Thank you. I have a question. Maybe Deputy Barcelona would be able to answer this. If this safety bill passes as is, how many inmates will be released from the Winnebago County Jail?
I can answer that.
State's Attorney, thank you.
Because I can't answer that, but assuming it's retroactive, okay, so let's talk about if it's prospective for a second. No one will be released on January 1 unless they post bond, okay? But assuming it's retrospective, what our office has begun to do, and our trial attorneys, is look at their caseloads. So let's say they have a caseload of 100 people that are currently in custody. So then first thing they say is, as the memo indicates, are they charged with an offense which is in the detention net? If the answer is no, that person is getting out on January 1. The next question is, what's the applicable standard? So there are lots of defendants who are detainable under the willful flight standard, but not on the dangerousness standard. So what our attorneys have started doing is, hey, here's the petitions that I believe I'm going to be able to file, and then secondarily, here are the ones that I think we have a chance of actually winning. And one of the challenges we're having, and why our estimate is about, if the jail population stays at 800, is about half, is that we are not going to be able to meet the willful flight standard, and we won't have the dangerousness standard available to us. Furthermore, and the specific identifiable person dangerousness standard applies to many gun cases. Well, it's a challenge finding a specific identifiable person. You actually have to name somebody. So if you have someone who's in their car, the gun is in the glove box or on the front seat, and they're a felon, that's unlawful possession of a felon. That's a non-probationable, and it's under A1, 6.1A6. We have to prove that person is a danger to a specific identifiable person. Is that me? Who is that? And some people are okay with that. I think that standard personally is far too restrictive. So that's kind of what our estimates are based upon. But again, if the law is prospective, then no one would be getting out January 1, absent them, they're posting bond. And number two, the jail population might not be 800 on January 1 either. It could be 600, it could be 1,000. But based upon our, I think, pretty solid projections, that's what we think is likely to happen.
Thank you. I'm going to Ms. Red, and then we'll come back to you.
Thank you, Chairman. I guess with the pandemic and everything that has been going on, I have been on a Zoom call with Representative West about this pretrial act. I guess my question to you, because I heard Mr. Booker say that, and I guess my question is, have we attempted to contact Representative West and have him come and speak to us? And I'd like to see that documentation. I would. All the departments that are affected, the state's attorney, the chairman, the sheriff, I'd like to see that. Because he's not here to defend himself. And I know I've been on a Zoom call with him, and we talked about this. But that was at the request. The organization requested that he speak with us about it.
Very good. Thank you, Ms. Red.
I would like to point out that I've talked to Representative West and Representative Vella and other representatives about this law at length. I, in fact, sent a memo. I'm not a Johnny-come-lately. I sent a memo to all legislators outlining much of the concerns that I raised in my op-ed almost a year ago. And so we have been talking to legislators, and to their credit, they've been listening to us. As of yet, they have not acted on the concerns of the 100 states' attorneys.
That's true.
Just a follow-up. Do you have documentation, something, an email that you sent requesting?
Yeah, I have a memorandum. I'm going to be happy to share it with you.
Yeah.
And it was addressed to all legislators. I think
Shoot it
was
over
March.
to me, please, please.
Absolutely. I'd be happy to.
Thank you, Ms. Red. Yes, Ms. Fellers.
I went to Rep. West's website on my cell phone and saw that he had 2 public town halls and 2 public info sessions on this, and that's just a casual viewing on the first page. So I just wanted to defend Representative West on that. I know that he had also invited Speaker Welch to come and speak to the community as well. But I have a question for State's Attorney Hanley, please. I have 2, actually. Does the release, oops, okay. Does the release of these people who are incarcerated mean that they're free and clear and that they will no longer be prosecuted?
No, so there'll be two things. One, their cases will still be pending, and two, they'll have pretrial conditions placed upon them. So the category of defendants that I talked about that would be getting out of jail January 1, either because they're not in the detention net or because the standard wasn't met, either dangerousness or willful flight, the judge would still have to actually impose the least restrictive pretrial conditions. So those include not committing crimes, coming to court. It could potentially include, no drug or alcohol use, certain assessments, obtain your GED. There's a kind of a menu of pretrial conditions that will be placed on defendants.
Okay, and my second question is there any single detainee who may be released on January 1st who would not be able to bond out today?
Can you repeat that again?
Is there any single detainee who would hypothetically be released by this bill on January 1st who could not bond out today by posting a cash bond?
I don't believe so. There could potentially be someone who's held currently without bond, but I don't think so. So the answer is almost certainly no.
So hypothetically, I could go bond out all of these people this evening?
Absolutely.
Nothing, okay, thank you.
Thank you, Mr. Huffman.
Thank you, Chairman. I was at a meeting last night at the Democratic Party, and Representative West was there, spoke about this topic. And from what I heard, that this is not a finished product, that they're going to go back and work on it. So I think we actually need to wait to see what the product actually comes out. So he was pretty clear that this is not a finished product.
Thank you, Mr. Huffman. Okay, Mr. Webster.
Yeah, thank you. It would seem that all of my colleagues, whichever side of this issue you stand on, for or against, everyone that has spoken has made some mention like, well, we don't really know what's in it. We don't really know how it's going to go. We don't know, for sure how that will proceed. We won't know. Well, like, you don't know what's in the bill till you read it, sort of thing, okay? So those comments that I'm hearing, they're universal comments from all of us in this room, for or against. That alone is the very reason to repeal this or put it on hold till they work on this thing and get the bugs worked out of it. With that, please call the question.
Mr. Neighbors had his hand up while you were speaking, so I'm going to allow Mr. Neighbors to.
I wanted to call the question.
No. That's two call the questions. Okay, so let's just back up and remind, we are voting on an amendment to this resolution that Mr. Sweeney brought forward, correct?
I think we already passed the amendment.
I'm sorry. We have to vote on the call of question? Okay, are there any board members opposed to calling the question?
We already passed the amendment.
Yeah, I think there was a second. Mr. Webster. He was either first or second, and Neighbors first or second. So is there any board members opposed to calling the question? Hearing none? All right, we will call the question. Just
What's the question?
the question is the amendment to the resolution for the whereas.
We already amended it, did we not?
Yes.
I think we did amend it.
Let's just take that vote again. Because State's Attorney,
Yeah, we did. We had a voice.
We amended it.
Yeah, we did a voice one.
The amendment, yes, because Mrs. Red voted no and all others were a yes to the
Okay.
amendment.
so that was already amended. So there is a motion.
Yes, I would make the motion to pass the resolution as amended.
Okay, and we have a second by Mr. Lindmark. Is there any discussion on the amended resolution?
I don't even remember what the amendment.
Are there any board members opposed to this amended resolution? All right, let's take a roll call, please.
Thank you, Mr. Chairman. We will start with Mr. Tassoni.
Yes.
Mr. Webster.
Yes.
Mr. Westcott.
Yes.
Mr. Arena.
Yes.
Mr. Booker.
Yes.
Mr. Butita.
Yes.
Mrs. Crosby.
Yes.
Ms. Fellers.
No.
Mr. Gurl.
Yes.
Mrs. Gorel.
No.
Mr. Hoffman.
No.
Mr. Lindmark. Mr. McCarthy.
Yes.
Mr. McDonald.
Yes.
Mr. Neighbors.
No.
Mrs. Red.
No.
Mr. Salgado.
No.
Mr. Schultz. Mr. Sweeney.
Yes.
Mr. Chairman, 13 yes, 6 no, 1 absent.
Very good. The resolution has been approved.
The numbers can't be right.
Mr. Gurl?
Thank you, Mr. Chairman. That concludes our report.
Thank you. Thank you, Mr. Gurl.
I know how Ted Biondo felt.
How Ted Biondo felt.
All right, I think these meetings go this long, we need to have Mr. Thompson bring snacks in with sugar. Unless you have some insulin I can take right away.
I'm fresh out.
They booked. Did you hear those numbers?
So we'll move on to, I
13
believe, new
yes, 7 no, 1
business.
absent.
Is there any new
Animal.
business in front of the county board this evening? None? Announcements and communications. Clerk Gamal.
Unfinished business?
No, not yet.
Oh, not yet.
Not yet. We'll come back to it. Announcements, communications?
Thank you, Mr. Chairman. I would like to announce that today was the first day of early voting in Winnebago County. We serve 33 voters at the County Administration Building. Early voting is from 8:30 to 4:30. Also, if you requested a vote by mail ballot, those were put in the mail today. If you did request a ballot to vote by mail, you must vote by mail. The election is November 8th, and most of you are up for election, so make sure you cast your vote. The rest of the correspondence was received, listed as below. Thank you.
Thank you. Go back to unfinished business. Mr. Salgado?
Yeah, just, I forgot to thank Mr. Rickard and Mr. Thompson and the finance staff for all their hard work on the budget. As they walked out, I was like, oh crap, I forgot to give them credit for it, but I do want them, if you could please extend that to the staff.
Ms. Red, you had your hand up?
Thank you, Chairman. I think this is unfinished business, but it needs to be on the records because I'm not going to be here much longer. And I have people calling me for the Ring doorbells. Now, I did put in for my Ring doorbells, and I've heard 2 different answers. So can someone tell me what's happening with my Ring doorbells?
Did someone answer Ms. Red's question? Mr. Gurl?
Thank you, Mr. Chairman. There will be a round 2 giveaway, and that will follow the first round, and that will be probably in middle of November, right around there. So that's the plan as of now.
Nobody gets a Ring door.
Thank you. I just wanted to be on the records. Thank you.
You're welcome.
Good. Any other unfinished business? Mr. McDonald?
Thank you, Mr. Chairman. I just have a comment along with that. Are county board members eligible for the Ring doorbell? Okay, I was just curious about that.
As of now, there are only the requirements of being a homeowner, having Wi-Fi, internet, smartphone, tablet. This is a crime prevention, crime prevention tool, so the more Ring doorbells, the better. It really wasn't about restricting who or who could not have them. I bought one personally just so I would know what I was talking about with the Ring doorbell, so I don't see why it wouldn't be a problem. Right now, there's 4 plus Dorothy, that'd be 5 board members that are participating, so.
Good. Mr. Neighbors?
And with the Ring doorbell, like myself, I had already allotted my money before the program was established. And I was wondering, would there be a possibility that there could be a countywide program for the Ring doorbell assistance.
Mr. Earl.
Thank you. I can also comment on that. We are working with Mr. Rickards' office to look at funding for this, and this is really going to be the catalyst, we hope, for a county-wide program. There's been a lot of interest from other districts, and, you know, my idea was kind of brought in a little late to the table. A lot of board members have committed their money already, so we can't really blame the other board members who gave already, but we would love to see this turn into a county-wide program to where we could have crime prevention throughout the county where it is needed, and pretty much every, you know, it'd be great to have a Ring doorbell on every corner. It'd be great to involve the community again with law enforcement and to bring that trust back, that knowing that the community has a say-so in the crime in their neighborhoods. Because frankly, I believe people are fed up with crime, especially crimes to people, persons, and property. So we would love to see this be a countywide effort, and I will be working tirelessly, whether I'm here or not. Come December, I would love to continue on and try to promote this program the best I can.
Very good, thank you. Any other unfinished business? Mr. Lindmark.
Yeah, I forgot earlier, I want to thank State's Attorney Hanley for coming out tonight. He works a lot of long days, and his clarification was very much appreciated. Thank you.
My pleasure.
Yep, thank you. Any other unfinished business? Mr. Webster. You.
Second.
Mr. Webster moves to be excused, second by Mr. Sweeney. All in favor, say aye. Aye. We are excused.